Counsel, approach the bench, please. Will you approach the bench? Did you find that case law, or are you still looking for it? Well, I think Mr. Holloman needs to know. We'll sit tight. I've told the bailiff to tell the jury we'd be delayed about 10 minutes. We don't need this on the record. Counsel, I simply forgot. Did you request a time warning, Ms. Byrne?
No, Your Honor.
Ms. Arnold, did you request a time? No time warning necessary. Mr. Holloman?
There's 15 minutes left and 2 minutes left if I get that for you.
I apologize. How many minutes?
15 and 2.
15 and 2.
I doubt I'll get that.
I recognize that, and I don't know that either side needs the time requested. You'll hand one to the bailiff for my review.
Now page 4, heads notes 4, 5, 6, 7, and 8. They're together.
You see it's on page 4, Charles. Page 4, head note 4, 5, 6, 7. Page 4.
Page 2.
Yeah, page 4.
Move.
Always doing good company without us rude.
Have you read that, Mr. Holland?
Must be a very old one.
Council approach the bench. This on. We need this on the record. For review, the state has presented the case of Sanborn, S-A-M-B-O-R-N versus State, 474 Southern 2nd 309, 3rd District Court of Appeal, 1985. It appears, Mr. Holloman, by this case that you are prohibited from arguing in closing argument what you believe to be perjured testimony. Which is not. Which is not. Okay. So I'm going to allow you to present the argument that you feel is appropriate. And if there is any objectionable argument, I'll charge the state with making such objections. I'm not going to limit your closing argument. Make the argument that you see fit. I'm not going to limit you. We're bound by if there's any contrary case law. I don't see any in front of me. At this time, we will need the defendant in the courtroom. Have you delivered their notepads to them?
Sir?
They have their notepads.
Get you that.
Go ahead and deliver them to them.
Charles has to make.
Noting the defendant's presence in the courtroom, counsel for the defendant are present. Counsel for the state of Florida are also present. The jurors' notepads are being returned to them at this time, which is immediately prior to them entering the courtroom. Counsel, are we ready for the jury to return?
State's ready, Your Honor.
This is
Hold space for it.
Please have the jury return to the courtroom. Good morning, ladies and gentlemen. Members of the jury, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Counsel?
May it please the court? Mr. Holman, software. Good morning, members of the jury. I want to start by thanking you for the time you've given during this trial and for the attention that you paid. I know that it was a long trial. I believe there was about a little over 40 witnesses. And I thank you, because without you guys, we can't do this. And I want to start by getting back to what this case is about. A 15-year-old child is dead, murdered in the most horrific way. His name is Seth Jackson, and he is the victim in this case, not the defendant, Michael Bargo. Michael Bargo was not framed, and he was not simply misunderstood. He confessed to 8 people that he shot and killed Seth. And these are 8 people that had no grudges against the defendant, no reason to come in here and lie. And in fact, some of those people could barely get through their testimony without crying when they tried to recall what the defendant had told them. The defendant, Michael Bargo, wanted Seth Jackson dead. He planned his murder, and he carried it out. Now, the facts and circumstances surrounding this case are so gruesome that most of the people that testified that the defendant confessed to them said, "We didn't believe it. We didn't want to believe it. We couldn't believe something this horrible had happened." And you've seen the pictures, and they're horrible. The bones and the remains. So what I want to do is start off and show you something that you haven't seen yet. It's been entered into evidence, but it hasn't been shown to you. And it's a picture of what Seth Jackson looked like alive. Because you haven't seen it. And that's what he looked like before he was murdered by the defendant, Michael Bargo. Now what you're going to get to take back with you is something we talked a lot about in jury selection, which you haven't seen yet, and that's the law. And you're all going to get one of these packets, and this is what it looks like. And it's called the jury instructions. It's going to give you all that law we talked about forever that's seen during jury selection. And I have some of this up on the screen for you so we can talk about what exactly the state has to prove to you for you to find the defendant guilty. But what you're going to find in here also, I just want to briefly touch on it, is something called lesser included offenses. And that law is in here as well, but I'm not going to go over that with you on the PowerPoint. You're going to find some lessers, one called second-degree murder. And that's basically there's no premeditation, and the defendant killed Seth out of ill will, hatred, spite. say, for example, they met up on the street. Michael Bargo hated Seth. He took out his gun and shot him. And I'm going to submit to you that doesn't apply in this case because there's clear evidence of premeditation, which we're going to go over later on. So I suggest that doesn't fit this case. Then you're going to have another option, which is manslaughter. And that's if Michael Bargo had done a criminal act, some kind of act. He didn't intend to kill Seth, but he did some act without premeditation, no evil intent or ill will. And again, clearly that doesn't fit the facts of this case. But I just wanted to mention those because you are going to be able to read about those. But what he's charged with, and what we've proven to you beyond a reasonable doubt, is murder in the first degree. And this is exactly from the jury instructions. It's in this packet, and this is the law. There are only three things, three elements that the state has to prove to you beyond a reasonable doubt for you to find the defendant, Michael Bargo, guilty of murder in the first degree. And that's it. And you don't see up here any numbers that say who was sleeping with whom, who broke up with Seth, who broke up with Amber. None of that's on there. Because we don't have to prove any of that. We have to prove one, Seth Jackson is dead. Two, the death was caused by the criminal act of Michael Bargo. And three, there was a premeditated killing of Seth Jackson. If we prove to you those three things, and only those three things, beyond a reasonable doubt, you must find the defendant guilty of murder in the first degree. And let's go through those. Number one, Seth Jackson is dead. Now normally, in a murder case, you have a body. And we wouldn't have to present so much evidence that Seth is dead. And I know we spent a lot of time doing that. But we have to prove it to you beyond a reasonable doubt. And because we didn't have a body in this case, and somebody that could come in and say, yes, that body is Seth Jackson, we had to present all this evidence to prove it to you. And the reason we didn't have a body is because of the great lengths the defendant went to try to dispose of it. By burning it, pulling his teeth, throwing it in the lime rock pit. That's why so much time was spent on this issue. And this has clearly been proven beyond a reasonable doubt. Like anybody who's going to say that Seth Jackson is not dead. He hasn't been seen since April 17th of 2011. And that's why those questions had to be asked of his mother. It's terrible to have to ask a mother, when's the last time you've seen your child alive? But that's part of what we have to do to prove it to you. 3 paint buckets are found in the quarry with Seth's charred remains. DNA tests have to be done, and they are, by FDLE, and they confirm that those remains are the biological child of Sonia and Scott Jackson. We have all those bones that are found in the fire pit at Charlie Ely's house, and then the DNA test done by Bodie Labs, that was on the bones from the fire pit. They say they can't exclude those remains as being the biological child of Sonia and Scott Jackson. Dr. Warren testified that the bones came from one individual, a male, between the ages of 14 and 17. And, probably most importantly, both Kyle Hooper and the defendant both admit Seth is dead. The defendant denies he did it, but he admits Seth is dead. That's number one, the first element. That's clearly been proven beyond a reasonable doubt. 2, the second element. The death was caused by the criminal act of Michael Bargo. That's the second element. These are the people the defendant confessed to that he killed Seth, or made some admission to. 8 people. Kristen Williams. Well, let's pick a couple. When she came in here, she could barely testify when she had to tell you what Michael Bargo told her. She had hesitate, she was crying, she was upset. If the defendant had just told her what he said, somebody was shot and killed with my gun, is that the way she would react? She would have said, no, he told me somebody was shot and killed with his gun. That is not what he told her. It's common sense. Her boyfriend of a year and a half told her, I shot and killed a kid. She was with him for a year and a half, and that is why, when she came in here, she could barely tell you that. You have Crystal Anderson. Obviously, she could barely even get through the door. I mean, she hesitated at the door. You all saw that before she even came in. And she sat on the witness stand. She had to turn her chair at one point. She couldn't even get it out. And they were all firm on, he said, I shot and killed the kid. There was no shaking them on that. And again, there's no reason for these people to come in here and lie. He admitted when he testified, yeah, they were fine. I hung out with them. There's no grudge with these people. There's no reason for them to come in here and say these things. And interestingly enough, David Smith, he was a very short witness. He was the corrections officer. And he came in and told you, I overheard the defendant admitting something to another inmate. And it's interesting what he said. And it's more interesting after Kyle Hooper testified. Because what David Smith heard the defendant say is, there's only 2 people that saw me shoot him. What does David Smith have? What reason does he have to come in here and make that up? If he was going to make something up, it could be something better than that. So he hears that. The detectives say, okay, write it down. And you can see that he was reading from that. He had a statement that he had written down on the day it happened. The exact quote. And after Kyle Hooper testified, what did we learn? There were only 2 people that saw Michael Bargo shoot Seth, because the girls had run into the bedroom. If you recall, Miss Arnold asked Kyle Hooper, once you guys started beating Seth, what did the girls do? They both ran and hid in Charlie's room. Who would know that? Who would say that? The person that shot Seth. I mean, again, it fits perfect. It fits perfectly. He can't get around these people. Maybe one person says, yeah, he told me I shot him. Okay, maybe they misunderstood. The he or they. Not 8. Not 8. Beyond a reasonable doubt, this would be enough, but there's more to prove that he actually shot Seth and caused his death. And this is just more about why those people are not making it up. As we went through, there's nothing in the paper or the television. Detectives didn't tell them any detail. Defense attorney tried to suggest they read it on Facebook. They're like, we're sitting around a burn barrel drinking some beer. We weren't on Facebook getting the details of the murder. They didn't know anything about it. All of the defendant's confession matches the physical evidence. So besides all the people that he confessed to, I submit to you that alone is enough. You confess to 8 people, that's proven beyond a reasonable doubt. But everything that he confessed to matches the physical evidence that's been presented. For example, he confessed that he shoots Seth with a .22 caliber gun. He owned a .22 caliber gun. Michael Proctor sat here and said, yeah, I traded it to him, I owed him money for work. He admitted that was his gun. There's no question that was his gun. And Megan Albany, if you remember, and Kyle Hooper both testified that the defendant always had that gun with him. He always had that gun with him. And the firearms expert testified that the projectile sent to her from the medical examiner's office, the one that they did recover, was a .22 caliber bullet. And there was some cross-examination, well, we don't know for sure that it came from that gun. Well, we do now, because the defendant said so. He says Kyle shot it, but he admits that it was his gun. So we know that. We know that Seth was shot with the defendant's gun that the witnesses say he always carried on him. The defendant had an injury on his hand consistent with having come from the hammer of a firearm. And the defendant tells the evidence technician he got it from the hammer on his .22 caliber gun. Here's the picture. Judge is going to tell you to use your common sense. And many of you on the panel have guns and you hunt. You look at that picture. Is that from him firing over and over and over again when he killed Seth? The testimony is he shot him multiple times. And there's the physical evidence that proves it. He told Kristen Williams that the gun he used to shoot Seth was under a house. Where was the gun found? Under the house. That air vent duct had broken off, and that's where the gun was. Well, how did she know that? Because that's where he hid it, and that's where he told her he hid it. Defendant confessed to Crystal Anderson that he shot Seth 2 times in the face Those are the details that she said. And Dr. Warren testified he took x-rays of the skull and saw those metal flecks, those white, bright white spots that are on that x-ray. And those are evidence of a gunshot wound to the face. And Dr. Shaw also saw the same things. And he called it a lead spray. That's his description, a lead spray. And he took those x-rays, and he also saw the metal flecks. And he came to the same conclusion. The physical evidence matches up with his confession. Seth was shot in the face. And this is right here are these white flecks that the doctors talked about. Now, the defendant confessed to several people that he shot Seth multiple times, more than once. Shot him inside, he shot him outside, shot him in the bathtub. And how do we have evidence of that? How does the physical evidence match that part of his confession? One projectile is located in some tissue next to that vertebrae. The x-rays indicate Seth was shot in the face. So you got at least 2 shots there. One projectile in the tissue. You have the lead spray that's showing he was shot in the face. And then the evidence technicians locate in that fire pit what appeared to be 5 melted bullet fragments in the fire pit. I don't know if you remember when that picture was shown, but that's what she was talking about. These are all found in the fire pit. And again, that's the physical evidence matching up with the defendant's confession. And he was shot at least 8 times. The defendant told Crystal Anderson that Seth's skull didn't burn all the way, so he pulled his teeth out. Part of Seth's skull was found in that lime rock pit. And what else was found in the lime rock pit? A human tooth. That is part of the skull that was found. And that's the tooth. He's telling the details of exactly what he did. And everything is matching up with that. The defendant confesses to numerous people that he put Seth's remains in paint containers and he threw them in a rock quarry or a body of water. That's where his remains are found. In the lime rock pit that he admits, and he admitted on the stand, I think he even admits to swimming down and touching the bottom. He knows how deep it is. He admits that was his idea. He told him where that was. I told him where that lime rock pit was. He's the only one that knew where that was. He swam there, and his girlfriend was Kristen Williams. She lived less than 1 mile. And look where they're found. He confesses that he burned Seth's body. He's got burn marks on his face. And the pictures are in here, and you can look at the pictures all you want to. It's burn marks on his face. It's not from a beating. It's not black and blue from a fight with Kyle Hooper. And he told William Faulkner that when he was burning the kid's body, he threw an aerosol can in the fire to make it hotter, and it burned his face. And then you heard from Tracy Wright. What did she tell you? On Monday, the day after Seth was killed, his face was messed up. And she said, she asked him, what happened to your face? And he said he burned it in a fire. He told her, I threw an aerosol can in the fire. And if you want to talk about evidence matching up, think about how what Tracy Wright and William Faulkner say about the aerosol can matches up with what Julie Cunningham tells you. Now, those people don't even know each other. Julie Cunningham is the neighbor. They lived with her husband, and they came out to address the fire being hot. Tracy Wright has no connection with her, and William Faulkner has no connection with her. Her testimony was to you, at first, we see what we think is an orange glow, and then we go out and investigate the fire. And then we tell them, watch the fire. We come back in. And her exact quote was, then she saw at her window flames. The exact quote from her on the stand was, it was as if they had accelerated the fire. She's testifying it was as if they had accelerated the fire. And he has burn marks on his face and is confessing, I threw aerosol can in the fire. He's trying to accelerate the fire. And the neighbor who has nothing to do with them is saying, yeah, it seemed like somebody was accelerating the fire. that's number 2. That was the second element. I mean, there can't be much more evidence than that. You confessed to 8 people, and all the physical evidence matches up with exactly what you said. Did he cause the death? Yes, he did. Absolutely. That's element number 2, proven beyond a reasonable doubt. You got one more element. Was it premeditated? That's the last thing we have to prove to you beyond a reasonable doubt. Was it premeditated? We know the defendant hated Seth, and he had numerous verbal altercations with him in the weeks leading up to the murder. Sonia Jackson testified a week before Seth was murdered. The defendant told him, "I have a bullet with your name on it." What was it over? From what everybody testified to except the defendant, it was over Amber. Because Amber cheated on Seth with the defendant. And that's what they were feuding about. Not some song lyric about gangs. And think back about how interesting it is that when we go through the list of all the people the defendant was seeing, all the girlfriends he had, and all the people he was sleeping with, who is the one person that he will not admit he is either sleeping with or in a relationship with? Amber Wright. Why does he not want to admit that? He's admitted a whole host of other girls he's seen at the same time. Why deny that you're with Amber Wright? Because clearly, that's why you got into it with Seth. That's why you hated Seth, and that's why you killed him. You don't want to admit that. You want to distance yourself from that. But you can't distance yourself from the fact that numerous people saw you guys together, saw you kissing, saw you holding hands, and you have her initials tattooed right here. And we have pictures of that. And she has your initials tattooed right here. Why do you have that? And the defendant said something about killing Seth to the group while James Havens was still there. They were talking about it early on, about killing Seth. And this is hours before the murder. And Kyle Hooper told you on the stand that everybody had a specific role. It didn't go as planned, but everybody had a role. You can't be more premeditated than that. Let's plan it. What are we going to do? Amber and Charlie are going to lure Seth to the house. Michael Bargo told them, that's your job. You get Seth here because Seth is not coming for anybody else. Michael Bargo already tried to get Seth to meet him, if you recall what Will Samalot said. And then they went by Charlie's house, and he started firing a gun at him. There's no way Seth is coming to this house because the defendant asked him, or because Kyle Hooper asked him. The only people that can get Seth to that house are Amber and Charlie, and the defendant knows it. Roach, Justin Soda, was supposed to have a stick or a board. He was supposed to hit Seth once he got in the house. And then the defendant, Michael Bargo, and Kyle were going to come out and beat Seth up, and then the defendant was going to shoot him. You can't get more premeditated than that plan right there. But you have more. That's enough, but you have more. The defendant planned to burn Seth in the fire several hours before the murder. You have Larry Jenkins. Again, these are people, he's a neighbor. He doesn't know him. He's got no problem with Michael Bargo. He comes in and says, yeah, I'm out there to smoke my second cigarette of the night. I see Michael Bargo by the fire with Amber Wright. It's just the two of them. It's not a group starting a bonfire. And Amber Wright says to Michael Bargo, is it time to light the fire yet? And he says no, because it's too early, and the plan will call for that fire lighting later. He wasn't out there, as he tried to say, because he was worried the fire marshal was going to come and give him a ticket because there was a burn ban. James Havens said the defendant said something about texting. James Havens said, I heard him say something about texting to get Seth to come to the house. And the text messages show the premeditation beyond a reasonable doubt. The text messages alone, which you're going to see in a minute. Just those alone show premeditation. But you've got tons of other things to show the premeditation. Now I'm going to end with the text messages and the premeditation. That was the third element. We've proven those three elements, which has just been an abundance of evidence of those three things. Beyond a reasonable doubt, you have to find him guilty of first-degree murder. And the next thing I'm going to show you are the text messages that were taken off Amber's phone. And they're going to show you how premeditated it was to get Seth to come in. This is how they start. You can see the time at the bottom says 8:12. Amber at 8:12, and this is hours after they had talked about it, texts Seth, "Hey, can you talk?" Seth texts back, "You said you needed to talk?" Amber says, "Well, I kind of need to talk to you about us working things out." 8:46. Seth says, "What do you mean?" Amber says, "Can you please call me like now?" Seth says, "Yeah, sure." She says, "Hey, my friend Charlie's coming with. I've been telling her everything between me and you, and she's coming because I need her to help through this. Is that okay? But don't tell anybody what's going on, because I want to make sure we can work things out before anybody knows." And how premeditated is that? And by the way, don't tell anybody. Seth says he knows. Everybody's told him, stay away from her. Amber, if you have me jumped, I will never give you the time of day. So if I get jumped, say goodbye, all right? No, she's going to smooth it over. "I swear you're not, Seth. I could never do that to you. I just want me and you back." And he says, "Okay." And then he says, "Sorry, I didn't want Will to hear me, but stay around the corner where me and you fought. Just wait there, and I'll be there in a minute." She says, "I'm walking up the hill now. I'm at the neighborhood road. Where are you?" 9:08. And we know what happens after he meets her at the neighborhood road. And those three elements have clearly been proven beyond, to the exclusion, very reasonable doubt. Michael Bargo wanted Seth Jackson to die. And as he told James Haven after he murdered him, the deed is done.
Could we have that podium repositioned, please?
We take a brief recess, sir.
We'll take make it an approximate 20-minute recess. We'll reconvene at 10:05. The jury may retire from the courtroom. We'll be in recess until 10:05.
You connected? Yeah. You want me to stand by? Or?
No, it's good, sir. 2 is better than that.
Okay.
Sorry about that. She was calling going on. Can I have a couple? My niece is ready.
have her check her phone for text messages or give her some information that we may need at the Okay, thank you.
Really, because the doctor told mother
She's looking.
I need to get. Yeah.
I really don't know. They did, because I know my dad did some research. I think it was like a rebate. It was like a pay back.
Yeah.
So I don't know what it was. It wasn't the whole amount. And then
Did you get my get well basket?
Did you have fun?
Oh, yes. It really did.
Is that a cool place to go?
It was great. Yeah. The kids were visitors coming back and running to do it. Certain places were you didn't want to be around. They wouldn't even let us walk through there. They were trying to sit our adults only in
Oh,
here.
that's
So,
good.
which I thought, was good.
Yeah, yeah.
Yeah, plenty of stuff. I mean, I was so tired. I was by 8:30. We were all asleep because you were, the dolphins.
Yeah.
With the dolphins and the sea lions.
Oh, yeah.
You know, all that good stuff.
Well, that's good. It's good to go.
Let's do that. Yeah.
See, I'm always so anal. I can't.
I was, well, I kind of a little bit regretted it. I was like, oh my God. But we were ready, so it was okay.
I'm never ready.
Yeah.
In my mind. Ever.
Well, you think, yeah.
And I cannot let go. And the best thing to do is go away. Chill.
Yeah.
Sleep.
And right, and not.
I don't sleep for a day.
Yeah, no. I was Robin was like, all right. Yes, we know the case. Yeah, we're ready.
Yeah. Yeah, you should, because you've done, you did
don't see it.
female.
We tried Bravo, Kyle, Amber, and Charlotte doing it.
So you ought to have it down.
Yes, but, it's different. Some is different stuff like that. We know this.
But I'm telling you, I never know. Never, ever. Now,
What arguments were you told me?
when?
I don't know.
I need to find out.
Yeah.
Well, the firm from up north supposedly is doing it. And you know,
He said he wrote some 50-page brief, and the only issue was the Sheridan's 9, which is the damage. That's what I haven't looked into it yet. That's what Nick said. I was like, really?
the what?
The only thing they argued, like 50-some pages, was the Sheridan's 9, which was the DOA. I'm like,
Are you kidding
when
me?
this is over, I'm going to ask him because I haven't read it. And I'm pretty sure he's been talking to them. There wasn't. And
I mean, I
yeah.
felt like I was on top of it. But, I mean, they're going to go after me at 30, 50. I mean, they've already pseudo-demanded all of my files. I told them, you have the record on appeal. And
Well, that's okay because
the
I recorded all the
3850
jail calls from the shit you guys.
Oh,
I make sure I recorded any of those that I listened to
Okay.
for when that comes about. You loved her up until when you got convicted, and now you're mad. So
yeah.
because they loved you, they thought the world of you,
Well,
and
that's
you did a great job. So I
And
copied all those.
They hate me, which I had
Yeah.
nothing to do with the case. Except the one day I come in and help fix the jury instruction.
Maybe.
We're talking about
How's she doing in prison? Really?
That were all two corrections officers, her and female corrections officers, and two other inmates. Now they've got this no one's supposed to know illness going on.
Yeah.
People died.
Honestly, that's terrible because I really thought she would get there and then get involved in some kind of group thing, and help
I think she would,
younger
except,
people that are there. Oh, that's
have you watched Orange is the New Black?
no.
On Netflix, you've got to watch it. You've got to.
What is it called?
Orange is the New Black.
No.
It's, yuppie, blonde, cutie pie. 10 years in the past was having a relationship with this woman who was a she didn't know. and her lover had her delivered out. And so all these years later, when they finally and she breaks up with her now, she's engaged to a guy, getting ready to get married. And someone rolls on her. And so she now has to go to prison.
I saw that ad. Is it funny? I've seen that. I've people wrote about that or something like that.
Yeah.
I have seen that. She's in that's the one.
And she is so...
When is that on?
We can play it on Netflix. You
Oh,
can get it
Netflix.
anytime
Okay,
you want.
yeah. I have heard that.
So, it's kind of funny, but you know...
Anything to take our mind off.
Her family.
Here's your taser.
They find I didn't do something, okay? And then you
Not
heard
worried
about
about that.
John's war.
I heard that story. Oh, yeah. Jonathan Lloyd, the expert. Oh, the expert, yeah.
I can't believe that. And apparently he was that upset.
Yeah.
And he had to go back in. Yeah, bond revocation.
Okay. Oh, that's shorter than people pulling teeth out. And then toothbrush. I was going to. I forgot about it.
Are you doing that?
I'm doing the rebuttal card.
And then you're doing that?
Well, we're doing it together. Right. See what it says?
Okay, so you need to tell me if there's anything specific. Some blank paper down. So I'm not gonna be very long.
No, honestly, I don't think we need to.
I really don't feel like I'm finished. I'm gonna.
Alright. I mean, that's good.
I'll get over this hole.
Yeah.
Probably don't take.
$5 a day.
I'm just gonna argue how hard there's a lane that he talks about reasonable doubt kind of rise from the conflict. I may or I can't even imagine it. I can't wait. I'm like, I don't think he will.
I don't leave the office, like, do it.
You can't.
I have anything written down. Scribbly words.
School, you know John Bianco?
I got myself at first,
The
like,
academy again. We
it's
work.
not usually that much, skilling out and that, I'm like, do it. That is what it is. Not a big skill. Oh, yeah. Truth comes out. Truth is in the grass.
She laughed. Oh, yeah. splat, and he had to pull me out and do it. And you should use your common sense in deciding what evidence is wrong and what evidence is true. I'm gonna do it. I can call you with your being too sarcastic. Did you like how you're misunderstood back into the psychology? And for them to believe his testimony, they have to believe every single one of those 8 people either misunderstood what he said or they're flat out lying. That's what it is. And why? Okay, maybe one guy becomes one and I'm right. And then he goes, I don't know if they really could put that together, so I think that's what it was. And see, that's the one statement that he didn't address about being misunderstood. He was testimony. Seemingly insignificant, but it really is significant. It's the only statement that he didn't poo-poo.
He can sit there. He worked with y'all, right?
Yes, sir.
Yeah, he can sit there.
Thank you.
We'll vouch for Adam. You only took by half an hour. Look, see what that was. Okay, well, it was 9:40. Yeah, it was 9:40. That's when I said 20, right? So 9:40, 9:45. No, we didn't start tomorrow 9:15. I think you're right, it was up 30 minutes. 25 minutes. No, it'll probably be about 10. If that. openings for this, but I couldn't put it in. I may, if it's police, I'm like, if I was gonna argue, they know he did that, because they never talked about it. They didn't put it out in the paper, when you talk about that. And every time you bring the one up, it's to you or I. Nobody says Robert. When who yes?
All rise. This court in Marion County is now back in session.
Go ahead and be seated, please. Noting everyone's presence back in the courtroom, please have the jury return.
Just in mind, like case law we looked at, that's what the court knows. I'm gonna restrict my argument accordingly to the extent I can.
As I mentioned at the bench conference, you can feel free to make the argument that you see fit to make. Noting that the jury has returned to the courtroom, Mr. Holloman.
All right, please, court. Ladies and gentlemen of the jury, I too want to thank you for the time that you've taken to go over this horrific thing. I want to put this case in context. We live in a world that is very different than it was 20, 30 years ago. Now, I don't offer this by way of any excuse or defense, but I want to set the context of this thing. What type of age do we live in? We live, well, they talk about wanting to find the weapons of mass destruction. You see that all the time on the TV. What country's got them, what country's building them, what country's going to use them. Well, technology has evolved to the point to where we have our own personal weapon of mass destruction right in our own pocket, our cell phone. And you see it every single day. Push a button, send a text. Saw it in this case. Push a button, post something on the internet. Ruin somebody's reputation. Push some buttons, get someone killed. If that's not the weapon of mass destruction, I don't know what. Now, the issues in this case is, have they proven their case beyond and to the exclusion of every single reasonable doubt? You heard the testimony of the defendant, and we'll leave that for what it is, but let me address some other things here. He was only 18 when this thing happened. You can see the circumstances that they were living under. Absurd. Where were the parents? Evidence of premeditation? I would submit to you this. I see the evidence of premeditation as to Kyle and Amber. Kyle and Amber are the key to this thing, because that is where the communication was. Now, Kyle gets up belatedly and says, well, Bargo was in on the plan. But I just submit that to you for what it is. We look at the, for example, the gun. And what I'm going to do is I'm going to go through this thing, and I'm going to point out reasonable doubts to you as to certain pieces of evidence. What about the gun? Okay, where did the bullet come from? Okay, and they said, Ms. Burton says, well, they solved that riddle because they say he shot. Did you see any other gun in this case? In the video, you saw what was clearly a .22 caliber rifle leaning against the wall. What part did that play? They talk about the gun, the marks on his hands. Well, let's see, where that piece of evidence. See that gun? Mr. Bargo says that that gun was wrenched from his hands in an argument. You remember that testimony? Well, you guys and some of the gals know guns. The injury that he received is more consistent with him wrenching it than firing it. Said there was a fight. You saw how the hole was dug in his hand. Now, you've got the credibility of these witnesses that testified, and all of them testifying is to his confessions. I believe it was 8 of them that they talked about, and you're going to have to resolve those issues yourself. What was his involvement? What was the quantum of his involvement? He testifies that his involvement was a mere accessory after the fact to this thing. The blood on the ceiling. There's a mixture of Kyle Hooper's blood and Seth Jackson's blood on the floor. They ignore that and they point way over to the kitchen where there's a speck of blood near a light fixture. Stephen Montanez, well, gee whiz, isn't he a sterling citizen? Because he witnesses all this stuff. Doesn't even pick up the telephone. doesn't even bother to call the police. Refers to it as the usual sort of North Jersey beatdown. Larry Jenkins from across the field. Larry Jenkins, 300 feet across the field on the road, as a matter of fact. He says, well, I heard time to start the fire, or is it time to start the fire? Could he have heard anything from that sort of distance? There wasn't any evidence anybody was yelling and screaming that. I would suggest not. The evidence suggests that he wouldn't. Julie Cunningham, she described the person as she identified as Michael Bargo as being a blondish person. Joanne Jenkins, she saw people moving things, wearing hoodies. And then you heard the testimony of Mr. Bargo about at least his involvement in dumping the remains. Cast impressions, well, we know he was wearing sliders. They didn't pick up any cast impressions. He said that. DNA test, they tested boxers, jeans, everything else. This case, is based on, is testimonial, but it has evidence, forensic evidence, that back up the actual acts of the shooting and the manner and means in which the death took place. But the testimony implicating Mr. Bargo is largely the testimony of other people. That's one view of it. It's other people saying he said something. But there's also the flip side of that too, in all candor. The argument would be that he's the worst witness against himself if that's to be believed. I know it's a stressful situation. It's horrendous allegations. But what I'm suggesting to you is this, is that we don't have to convince you of anything, because the law doesn't require that. They've got to prove their allegations to such an extent that there's not so much as one single reasonable doubt. Not a speck in the elixir, so to speak. It must be clear. Beyond and to the exclusion of every single reasonable doubt. And I submit to you that they haven't. And that a lesser included offense of second-degree murder is a more appropriate sort of verdict. Because this conspiracy is loosely weaved in here. They put these text messages up here. These text messages are not Michael Bargo's text messages. Amber writes, these text messages don't mention Michael Bargo. The only person that, quote, tries to tie him to this, because there has to have been premeditation for it to have been first-degree murder. The only thing that ties him to this is a pack of liars and a pack of admitted killers. And that's it. When he, so to speak, gave that confession to what is known as the Stark people, he didn't talk about we made a plan. We made a plan that went wrong. When he gave those other statements, did he talk about a plan? He didn't talk about a plan. You didn't hear one single person talk about a plan. But the state stands up there and tells you, well, you got to believe there was premeditation. Now, does that convince you that he didn't premeditate? Probably not. Because I'd never be able to convince of that in that type of weather, so to speak. But what it does is it shows a reasonable doubt that he was involved in the premeditation of this. And because of that reasonable doubt, that third element is not met. Because it's not met beyond and to the exclusion of every single reasonable doubt. But what would be met? What would your verdict have to be? Guilty. Guilty as hell of second-degree murder. There's no question about that. Why? Because that has been proven beyond and to the exclusion of every single reasonable doubt. Look at how hard they've struggled on the premeditation end. For example, as I referenced, well, we've been casting aspersions against Kyle, so to speak. And we've been doing that for a good reason. Kyle said what? He wanted him dead. All right, I know what you're thinking. Bargo also said, listen, we got a bullet, I got a bullet with your name on it, so to speak. Or at least that's what they say, he said. this controversy with Amber, that was very fresh. That was about a week and a half away or less than this controversy that Seth had with Michael Bargo, which was a month or a month and a half dated. That's things that go into the consideration of it too. The entire plan was this. What happened was this. Mr. Bargo talked about it. Ordinarily, we don't talk about this in a trial, but Mr. Bargo brought it up. He asserted his right to remain silent once he was apprehended. He was the last person to be apprehended. All these other people were brought together. And there's been the suggestion, and it's there, that he made the comment, he tried to waffle around it a little bit, but he was asked, hey, you said, let's just hang this thing on Carl, or let's just hang this thing on Mike. We'll blame Mike. And that's exactly what they did. That's exactly what they did. Example. Did they do trace metals test? Or they do any other test? Luminol. You heard some testimony that they put, they put him in a chair? You heard that testimony? And they shot him in the chair? There wasn't anybody shot in the chair. There's no evidence of anybody being shot in the chair. You've got those types of things that are circulating around this case. But there's a reasonable doubt anywhere in this case. There's a reasonable doubt as to the premeditation. Because what they've done is this. There's a great sound and light show around that. Because you've got these graphic texts. You've got somebody luring somebody over there. But what you've got, too, is you've got the stamp of admitted liars and admitted killers. You didn't hear one word from the person that was the author of those texts, did you? Not one word. But yet those texts were presented. You see? It's not like just in everyday life. It's not like you're going to be convinced of a proposition simply because it's told to you. Like, for example, how do we learn things in school? We learn by visual aids, by the board, things like that. And it looks nice when it's all lined up, but it's lined up with all these other people. But you dig down to the heart of it because, you know something? You can be convinced back there as to probabilities. As to, say probably so-and-so did this, probably this, or I feel certain that this happened. But what I'm out for is this, and the judge will tell you this. It's different in the courtroom. It's very different. It's very different. Because you've got to put it to the proof to where it's beyond and to the exclusion of every single reasonable doubt. In other words, if you believe something, if you're confident it happened, that's not enough. There's a 1,000 reasons. That's not enough. If there's one reason that gives you a reasonable doubt. Dig into this case, because what we're getting ready to do is this. They're asking you to come back with a verdict of first-degree murder, murder in the first degree. And of course, with that verdict, we'll go on and we'll have what amounts to a second trial, second phase, as to whether or not they're going to put it, or whether or not you're going to make a death recommendation. So regardless of what you've heard about other cases or things like that, go back there and deliberate this thing, applying that standard of reasonable doubt. Because there is a verdict in this case that will do justice. There's a verdict that has more than adequate punishment. There's a verdict that jives with the facts, and there's a verdict where the case is proven beyond and to the exclusion of every single reasonable doubt. I am not going to stand up here and tell you that Michael Bargo is innocent, because he's not innocent. He's guilty. But he's not guilty as charged because of that reasonable doubt, only because of that reasonable doubt. Guilty of murder in the second degree. I ask you to return a verdict. Guilty of murder in the second degree. Thank you.
Ms. Arnold?
The judge is going to tell you, in the law that he gives you, you have to find the defendant guilty of the highest degree offense that the state has proven to you beyond a reasonable doubt. The verdict form that Ms. Burke talked to you a little bit about has murder in the first degree charged in the indictment at the top. That's where you start. If you find from the evidence that the state has proven all those three elements of first degree murder, you don't even get the consideration of second degree murder, manslaughter with a firearm, manslaughter, or not guilty. The state has proven beyond the exclusion of every reasonable doubt that the defendant, Michael Bargo, is guilty of first degree premeditated murder. Now, Mr. Holloman tells you you should discount the testimony of, as he quoted, admitted liars and admitted killers. Well, let's talk about that for a minute. On Friday, the state rested its case, having proved to you beyond to the exclusion of every reasonable doubt, without the testimony of Kyle Hooper, that the defendant, Michael Bargo, is guilty of first degree murder. You saw the evidence that Ms. Burke reviewed in the first part of the closing argument. Very little of that had to do anything with Kyle Hooper. The defendant's own statement about it's not time to start the fire. Do you know the timing of all that? That's at 7:30 or 8 o'clock, according to Mr. Lincoln. It's not time to light the fire yet. His statement to James Hayden, when he called him at 11 o'clock and said, the deed is done. That's all he said. How did James Hayden know what he was talking about if there had not been a discussion about the plan to kill Seth Jackson? There's evidence of premeditation, even apart from what Kyle Hooper said. But in rebuttal, we did call Kyle Hooper as a witness. Now, the judge is going to tell you that part of your job is to determine the credibility of the witnesses. The judge is going to talk to you about reasonable doubt. He's going to give you that explanation. He's going to tell you that a reasonable doubt may arise from a conflict in the evidence. There is clearly a conflict in the evidence, in the testimony of Michael Bargo and the testimony of Kyle Hooper. But just because their testimony conflicts does not mean there's a reasonable doubt. Because the judge will go on to tell you that you as the jury can believe or disbelieve any of the evidence or the testimony of any witness. And you should use your common sense in deciding what evidence is reliable and what evidence is unreliable. And he gives you rules to do that. How did their testimony agree with the other testimony and evidence in the case? How did they act on the witness stand? Who was more believable? The state has to prove all those three elements. It doesn't come down to who you believe, Kyle, Hooper, or Michael Bargo. But that's something you have to decide. And what Kyle Hooper's testimony does is fill in some of those details about how premeditated this crime actually was. That each person had a role, each person attempted to carry out their role. It didn't go exactly as planned, but that doesn't mean there wasn't a plan. Amber didn't text them soon enough to get them all in position. from Soto weren't part of this. Clearly they weren't. The defendant also had a part. It was his plan, his desire to kill Seth Jackson, but he needed help. He knew he couldn't lure Seth over there because of the stuff that had gone on before. And the argument between Seth Jackson and Michael Bargo was not stale. It wasn't old. It was ongoing. 7 days before, 7 days was when the defendant showed up at Seth Jackson's house and made that statement to his mom. He needed Amber and Charlie to lure Seth Jackson there. He needed Kyle Hooper and Justin Soto because, quite frankly, he needed the muscle to help carry out the plan. His plan. His gun. His desire. His hand that pulled the trigger. 7 days earlier, the defendant had stood in the driveway of Seth Jackson's house and said, "You're a punk, and I've got a bullet with your name on it." And he didn't just stand there and say that. He took his hand as if he had a gun and pointed it at him. "I've got a bullet with your name on it." 7 days later, again, he's standing over Seth as Seth is in the bathtub, already having been shot, already having tried to escape the residence, but having been dragged back in. And he has that bullet with Seth's name on it. And that was the point. Because he wanted Seth to know that it was Michael Bargo who had that bullet with his name on it. And he shot him in the face. And that, ladies and gentlemen, is the event. Michael Bargo is guilty of first-degree premeditated murder. The murder of Seth Jackson on April 17th of 2011. And we ask that you find him guilty as charged.
Members of the jury, you will have this set of instructions with you in the jury room during your deliberations for your review if necessary, but please listen carefully to me as I read them to you. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Michael Shane Bargo, Jr., the defendant in this case, has been accused of the crime of murder in the first degree. Introduction to homicide. In this case, Michael Shane Bargo, Jr. is accused of murder in the first degree. Murder in the first degree includes the lesser crimes of murder in the second degree, manslaughter with a firearm, and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Seth Jackson was killed by Michael Shane Bargo, Jr., you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, or murder in the second degree, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the three following circumstances. 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Michael Shane Bargo, Jr. may be found guilty of murder in the first degree or any lesser included crime. Murder in the first degree. To prove the crime of first degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1. Seth Jackson is dead. 2. The death was caused by the criminal act of Michael Shane Bargo, Jr. 3. There was a premeditated killing of Seth Jackson. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree are murder in the second degree, manslaughter with a firearm, and manslaughter. Murder in the second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Seth Jackson is dead. 2. The death was caused by the criminal act of Michael Shane Bargo, Jr. 3. There was an unlawful killing of Seth Jackson by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Seth Jackson is dead. 2. Michael Shane Bargo, Jr. intentionally committed an act or acts that caused the death of Seth Jackson. The defendant cannot be guilty of manslaughter if the killing was either justifiable or excusable homicide. The killing of a human being is justifiable homicide, and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Expert witnesses. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is only reliable when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Defendant testifying. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to the crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. Ladies and gentlemen, this is the verdict form that you will have in the jury room to be filled out by the foreperson. The verdict reads, in the Circuit Court of the 5th Judicial Circuit of the State of Florida, in and for Marion County, the State of Florida versus Michael Shane Bargo, Jr. Case number 2011 CF 001491-A-Z. That is referred to as the style of the case. And the verdict continues to read, verdict count 1. We, the jury, find as follows as to the defendant in this case. And then you will check only one of the furthest left-hand columns. You will check only either A, B, C, D, or E. We, the jury, find as follows as to the defendant in this case. A, the defendant is guilty of murder in the first degree with a firearm as charged in the indictment. B, the defendant is guilty of murder in the second degree, a lesser included offense. If and only if you check B, second degree murder, then you must make some following findings. You must answer 3 of the following questions by circling a response. 1, did the defendant actually possess a firearm during the commission of murder in the second degree? And then you will circle either yes or no. 2, did the defendant discharge a firearm during the commission of murder in the second degree? Then you will circle either yes or no. 3, did the discharge of the firearm result in death or great bodily harm to another person? Then you will circle either yes or no. C, the defendant is guilty of manslaughter with a firearm, a lesser included offense. D, the defendant is guilty of manslaughter, a lesser included offense. E, the defendant is not guilty. So say we all, dated this blank day of August 2013, and then there's a signature line for the foreperson signature. Today is the 20th day of August. And just to review briefly, on the verdict form, again, you check only one in the left-hand column, A, B, C, D, or E. If you check B, only then do you make further findings. Submitting case to jury. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. When you return with the verdict form, that is, the foreperson has a verdict form, I will ask the foreperson, number 1, has the jury reached a verdict? If the answer to that is yes, I will ask the foreperson to hand the verdict form to the bailiff. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. Your verdict finding the defendant either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror, as well as of the jury as a whole. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Ladies and gentlemen, as I just mentioned, in the jury room to be delivered to you will be the exhibits which have been received in evidence and the instructions on the law that I have given you during the course of the case, and the verdict form to be filled out by the foreperson of the jury. Members of the jury, you may now retire to consider your verdict. Counsel, we will be in recess until the jury either has a question or has reached a verdict. We are in recess. Those exhibits need to go to the jury room, and then we come back to these. Actually, I should take those in.
Okay.